Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I am a partner at the firm of Samfiru, Tumarkin, and the Western Canada practice leader with all things related to disability claims, insurance claims, and critical illness claims. Please send to us all your questions via the social media platforms and I'll respond to them as quick as I can. Hopefully we can have a good discussion today. I always find the questions quite interesting. Some of the questions I've never seen before. So if you have questions, please post them and I'll respond as best as I can within the time allotted. One of the things that comes up a lot is what is an independent medical examination? In other words, an IME in short. I always go back to basics. When you have a disability claim with an insurance company, the claim is based and governed pursuant to the policy. The policy is a contract that was negotiated between the employer and the insurance company. And in the contract, the policy, there are terms and obligations and rights to each party. At your end, when you submit a claim, you have a duty to prove that you are totally disabled within the meaning of the policy, that you're attending a doctor regularly, and that you are receiving appropriate care for your condition. At the insurance company's end, their obligation is to pay to you benefits when they receive sufficient satisfactory proof of claim. In other words, evidence to support that you're unable to work. And that often is where the dispute comes in. Is the evidence sufficient with the insurance company's position? That's when cases get denied a lot of the time. And at your end, you will feel that you've submitted enough evidence. So when the insurance company is questioning the evidence, at times, they may request you to attend an independent medical examination, as that term is phrased. Now, why can they do that? The policy in place, in other words, the disability policy under which you are making a claim for benefits, allows the insurance company, and obviously you always go back to the policy, always look at what the provision is. But for the most part, the insurance company has the right to have you assessed, and it will say quite often, as often as it deems reasonable, for you to attend an examination. So an independent medical examination, in theory, is where the insurance company pays a third-party entity, like another, let's say it's a mental health claim, that they may retain a psychiatrist who is not an employee of the insurance company to conduct an independent medical examination. What is that, though? The insurance company will ask you, will pose questions to the psychiatrist, have you attend a meeting and an assessment with the psychiatrist, and those questions will be related to what is the diagnosis, what are the restrictions and limitations, what treatment is the person receiving, is the treatment appropriate, are there restrictions and limitations that would prevent the person from performing the duties of their own occupation, are there other treatments that should be tried, etc. And when they receive the report from the psychiatrist, they likely will be governed in their decision-making by the opinion of that doctor. I have seen cases where that actually did not happen, where the insurance company did retain a psychiatrist, in this case it was a psychiatrist, and the psychiatrist provided an opinion supportive of the person's claim. The insurance company then had their own in-house doctor, in other words, a person who is an employee of the insurance company, not an independent medical examiner, reviewed the IME report and disagreed with the opinion of the IME doctor and still denied the claim. In a case like that, one would say that there is an argument for a claim for what is referred to as punitive damages, because the insurance company at their end have a duty to deal with you and to assess your claim in good faith. These contracts, these policies, are deemed to be peace of mind contracts. And the reason for that is they are supposed to give you peace of mind that if at any time in your working life you found that you were unable to work due to a sickness or an injury, that you do have the peace of mind that this insurance company will step up when you submit a claim, and that you have the peace of mind of financial security while you are unable to work. And because of that, the insurance companies do have, and this is based on decisions as they have progressed over the years from the courts, that these insurance companies do owe you a duty of good faith, and that they should adjudicate your claim based on that duty of good faith. Now, there's always often a dispute as to whether a claim is being adjudicated in good faith when a claim is denied. It doesn't mean that when an insurance company denies a claim that it is immediately a breach of their duty of good faith, because people do make mistakes. Insurance companies do make mistakes at times. But often when I see cases, I would see that the person who made the claim submitted satisfactory proof of claim. In other words, evidence supporting their claim as to why they could not work from their doctors. And the insurance company then either said we need further information, or may have sent the person for an independent medical examination, or was one of the things that happens most is I've had the person's claim reviewed by one of their in-house doctors, which they may refer to as our medical consultant or our health partner. Now, remember, that person has not had the benefit of seeing, meeting, speaking, assessing, or examining the person making the claim. All they do is that they file review. So they may look at your doctor's clinical records to see what are you complaining of, what are the restrictions and limitations that you report to the insurance company when they speak with you, what you report to your doctors when you speak to your doctors, and what treatment is being given. For example, again, if you speak about mental health, if the condition is such that it is getting worse, you have a major depressive disorder with a generalized anxiety disorder, you're not doing counseling, and you're taking a antidepressant at a very low dosage, that doctor may say you're not being appropriately treated, or if the condition had been as bad, as severe as you are reporting, then why is your medication so low and why you're not attending counseling? So it always goes back, and again, I'm going to sound like a broken record every time I say this. When you see your doctors, see them regularly. Report to your doctors your ongoing restrictions and limitations, your symptoms. In case of a mental health disorder, explain to your doctor what it is that is affecting you. Is it poor sleep? Is it oversleep? Is it nightmares, panic attacks that manifest themselves in a physical way? What else? Let me rephrase that. How is it affecting your activities of daily living? Poor concentration, poor focus, inability to multitask. Give your doctors examples so that when your doctor ultimately completes a form for the insurance company can see why you cannot work as a result of your mental health disorder, because so many people do have mental health disorders but do work. We'll get back to the IME in a minute. So we have a question from Danelda Strupp. Sorry if I got that wrong. I'm dealing with a recent injury at the workplace that will need significant time off. I am on STD, short-term disability benefits, but trying to get onto LTD, long-term disability benefits, and they are saying it doesn't qualify. Is there different coverage? Would a workplace injury be covered differently? It's a good question. So I often see cases where the short-term disability benefit is approved, yet the long-term disability benefit is denied. Now, short-term may be self-funded by the employer and adjudicated. The claim itself may be adjudicated by the insurance company where they don't actually pay it. They just communicate the decision to the employer who then pays it. Or the insurance company may be the entity that approves it and pays it. Or in some cases, the short-term may be adjudicated by and paid by one insurance company, and LTD is paid by a different insurance company. I don't understand why they often do this, where short-term is approved and then it gets to LTD and they suddenly deny it. Because why? If there had been no change in the business condition, why is it then denied? I have cases like that. People in my firm have cases like that, other lawyers. And these are cases that really, really should be pursued. Because if the evidence has not changed, if the medical evidence still supports that you're unable to work, there should not be a reason why short-term is approved but LTD is denied. The fact that it is a workplace injury could impact it, not based on the decision of whether the claim should be approved or not, but based on the fact that if it is a workplace injury, that the insurance company, especially the LTD ones, they look at this quite often. If it is a workplace injury, they're going to be saying to you, if your disability arises 100% as a result of a workplace injury, you should be applying to WorkSafe, because the policies will allow the insurance companies to deduct the benefits that are paid by WorkSafe from the LTD or the short-term claim. So even though your claim may be approved on the merits, the insurance company may end up paying you nothing, because the WCB payment, if the WCB does approve your claim, and it is a wage loss claim that is approved, the WCB payment almost always exceeds the LTD payment. So the LTD payment will be zero because the WCB payment will be bigger than the LTD payment. But still, and this does happen a lot, still submit that claim. Even if the employer says to you, well, no, we're doing with WCB, you don't need to submit a claim for LTD. The reason being, if WCB at some point stops the payment because they disagree that you're still disabled, if that does happen, and if you did not submit the claim to the LTD insurer, and now you want to go to them because you're no longer receiving money from WCB, the LTD insurer will say to you, well, you're too late. You missed the notice of claim and proof of claim provisions. So it is extremely important that you still abide by those provisions and submit the claim in a timely manner. Even if somebody like the employer says to you, well, don't bother submitting it, you have to. And if the claim is denied by the LTD insurer but paid by WCB, you also have to guard against something called a limitation period, where you have to file, if you don't do an appeal, you have to file a legal claim within a certain period of time, which usually is 2 years. In each province, there's an insurance act that has what is referred to as a limitation period provision, and the provinces differ. So you would want to know, what does your insurance act provide in your province with respect to the limitation period? Going back to your question, Donalda, though, if the insurance company is denying your claim for LTD, the question is, why are they doing that? If STD was approved, why is LTD denied? You're welcome to contact our firm, because we do offer free consultations where we can review your medical evidence, your medical chart if you have it, the policy, and very importantly, the denial letter, and discuss with you what your options are. In other words, we'll have a consultation with you on a free basis, review it, and then tell you these are your options, and you can make an informed decision as to how you want to proceed. There's no reason to wait to do that. There's no reason to first go through with an appeal. Find out from a lawyer who knows how to handle these cases what your options are, so you can make informed decisions. As you can see on the screen, you can go to disabilityrights.ca for more information. Then there's a question on YouTube from Janet Goring. I am an injured worker, but I'm a member of a union. Where can I go for a disability lawyer? I suffered a TBI/concussion. So TBI refers to traumatic brain injury. Janet is an injured worker and a member of the QP union. So where could she go to get a disability lawyer? In some instances, and I'm not sure about this one, in some instances, unionized workers will not be able to pursue a legal claim. It all depends on the collective agreement. The language of the collective agreement is the claim, if it were to be paid by a trust versus paid by an insurance company. So we would want to look at the collective agreement. And if you're an injured worker, I wonder if it's similar to Donalda's question, where if it is because of an injury that you suffered at work, remember, you may have to apply to WCB as well. But you're welcome to contact our firm and speak to our intake team to see whether it is something that we can assist with. There are unions where we can assist the members, specifically the federal unions. But in some cases, we are unfortunately not able to assist because of the collective agreement's wording. But contact us and we can review whether this is a case where we can assist. There's a question on Reddit from Callie. I'm currently off on LTD, in other words, long-term disability. I don't know if I can ever return to the same position and don't think I want to return to the company at all, if and when I'm cleared to do so. Should I resign from my position while I'm off? No, you should not. Few things to say here. The first thing that Kelly says is that she's receiving LTD benefits now, cannot return to the same position. Not sure if they could ever return to the same position, but doesn't want to return to that employer in any event. So if you're unsure whether you will be able to return to the same position ever, remember that the LTD policy will provide, if it is like basically most other policies, I always default by saying we have to look at the wording of your specific policy. But if there is a general group policy, it will provide that the insurance company will assess your claim based on whether you're able to perform the duties of your own occupation. For the most part, it's 2 years. And then after that, the definition changes. Then you have to prove that you cannot perform the duties of any other occupation based on your transferable skill sets that would pay to you something similar to your LTD benefit amount. In those instances, when you say you don't think you can ever return to your own work, I think your own position or the same position, that may not be what the insurance company is going to be looked at after a year or two, depending on when that own occupation period ends. So that's something you should remember. There are policies, and it's all dependent on the language of your own policy, where there is no change of definition. In other words, where the definition will always be, are you unable to perform the duties of your own occupation? Those are mostly individual policies that a person goes out and purchases themselves. Very, very few group policies will have no change of definition. Some policies may limit the payment to 2 years, others may limit it to 5 years, but for the most part, payments are paid to the age of 65. Why should you not resign? Because if you resign, you're no longer job attached, which is something that the insurance company looks at when the claim is being assessed. So I would not recommend that you resign. And there may be some form of severance paid at some point. And if you've resigned, then firstly, you show that you're not planning on going back to work, even though you may think about going back to work to a different employer, but the insurance company may not look at it that way. So for the moment, I would think it makes sense to not resign from your position, see what happens, and when you are clear to return to work, then you can make a decision as to how you want to deal with it. And if you did resign, you may also lose your extended health coverages. Then we have a question on Facebook from Arthur. I've been told my extended benefits will be ending and I will have to pay out of pocket to keep them in place. Can I pay for an individual health plan or will that cause problems with my LTD? I would think, firstly, speak to your employer and ask them, are you not able to pay for the premiums yourself? Because quite often while people are on LTD, at some point they may decide, or the employer may decide that they will no longer cover people for their extended health. If that happens, the employers in some instances may be prepared to have you pay for the premiums yourself and still keep you covered. If they say no, can you get your individual health plan? In other words, purchase a plan that covers extended health? Yes, I don't see why that you cannot do that, because your LTD claim is specific to can you work in a known occupation. And you have a separate policy that pays for coverages for dental or medical expenses that actually, in my mind, would be you taking steps to mitigate and trying to get better and trying to access the best treatment available to you. But first things first, I would think contact the employer to see if you cannot pay the premiums yourself. Then there's a question on Facebook from Arthur. This is the same question. Question from Praying Steadfastly. Are Canadian laws similar to American for disability? Different question to answer. I don't know what the American laws provide for. One would think it all goes down to what is the policy, right? When you speak about Canadian policies or how cases assessed, because it is a contract, these are not tort cases where you look at did the person cause negligence? Was there negligence that caused damage? Those are the three criteria for a tort claim. These are contract claims. So there is a policy in place. And because of the policy, it is a contract, as I said before. And the assessment is based on, are you entitled for benefits based on the language of the policy? If there were to be a legal claim, then the legal claim will be adjudicated based on Canadian law. And what happens is if you were to end up in front of a decision maker, in other words, in front of a court, the decision maker will make a decision as to whether you have met the conditions required to be eligible for benefits. And if so, then the decision maker will say, well, then the insurance company should pay to you benefits owing to date, instate your claim, but in some instances may also award damages. So I'm not sure if that answered your question, but you're welcome to contact us. Again, go to disabilityrights.ca if you've got further questions or you want more information. I've got a question on YouTube from Nina. Nina says, I'm going to be cut off my benefits in the next 3 months. The insurer says I reached the end of my 2-year period, but I'm still not able to return to work. What should I do? Okay. First things first, what I would suggest is contact us. You need to speak to a lawyer so that you can make an informed decision as to what you should do. We offer free consultations throughout Canada, other than in the territories and Quebec. And once we do that, if you contact us, we will ask that you send to us the policy, the denial letter, as well as other medical evidence that you may have in support of your claim. We will review those with you, discuss your circumstances with you, and then advise you of what your options are. And then you can make an informed decision as to how to proceed. As you see on the screen, you can go to disabilityrights.ca for more information. When we are retained, we pursue a legal claim. An appeal is a process, which is an internal process with the insurance company. For the most part, appeals are not even discussed in a policy. It is an internal protocol or policy that the insurance companies have, where if you were to submit an appeal, the same entity that denied your claim is now assessing whether you're eligible for benefits. And in certain instances, people do submit appeals where unknowingly they submit information that may not be helpful to their claim. When we are retained, we communicate with the insurance companies. There's no right to the insurer to communicate with you anymore. All communications go through your lawyer. You can focus on your treatment, seeing your doctors regularly, and it is incumbent on us to get you the best settlement that we can, based on the evidence and based on the lawsuit itself, because the lawsuit gives you power to negotiate. When you do an appeal, you have no leverage. Going to a question from Need a Break. My sister suffers from fibromyalgia and has been struggling to get a diagnosis and onto LTD. She has a lot of pain and mobility issues. What should she do to help her claim be approved? This is a great question. So, firstly, if she's already off of work, because if she's trying to get onto LTD, it sounds like the claim has been denied and she's now in the process of trying to get more evidence to support the claim. Fibromyalgia is seen as an invisible condition or a subjective condition. What that means is there's no X-ray or CT scan or MRI that is going to show to you, there's the MRI, or sorry, there's the break, like there would be on a fracture of a bone. Fibromyalgia cannot be seen in that context, yet it can be a profoundly disabling condition. Insurance companies often deny these cases because they say there is no objective evidence to support the claim, to support that the person has restrictions and limitations. There's also sometimes quite a lot of confusion in the medical community as to what it is and how disabling it can be, and very concerningly, what the treatment should be. I've seen cases a lot of times where doctors recommend through the insurance company that the person should just be more active. And quite often when that happens, the condition gets worse. So what should you do? What should your sister do? She should see her doctor very regularly, report the restrictions and limitations that she has, tell the doctor, implore the doctor to refer her to a specialist, to a rheumatologist, or a physiatrist, somebody who has the expertise of treating these conditions, and also hopefully assist with trying to get a claim approved. If the claim has been denied already and she's in the process of doing appeals, have your sister contact us so we can at least look at the documents and tell her what is lacking so she can make a decision as to how to proceed. I know I have, and also the other lawyers in my team have, represented clients with fibromyalgia for many years. I've got cases going on now. I know I will have cases in the future where I represent people with fibromyalgia, because invisible conditions are the ones that get denied the most. And that would be fibromyalgia, chronic pain that may be based on a myofascial etiology, in other words, that it is soft tissue based. It may be chronic fatigue syndrome or myalgic encephalomyelitis. These cases can be, or these conditions can be extremely disabling, but unfortunately, the medical evidence has not advanced to that extent that there are objective tests for this. Does not mean that there isn't a claim to pursue. So please do not be discouraged. If you do have a claim based on fibromyalgia, one or another condition, where the insurance company says to you, well, we've looked at it, we don't believe that your disability is such or that your condition is such that it is disabling, or we don't think that there is objective evidence to support the restrictions and limitations that you have, therefore we're not going to pay your claim. Don't feel that you don't have rights and options, because you do. Just because the insurance company says that you're not disabled does not mean that that is so. And that's where we come in. We assist people with these types of cases to get them the best settlement that we can, based on not just the lawsuit, but also the medical evidence. Because once we're retained, we contact doctors to get their clinical records, but also at times get medical opinions, medical reports that hopefully will support that you are unable to work. Remember, when you submitted a claim for disability, I always say this to people, when you submitted a claim for disability benefits, you needed to submit 3 documents. The first document is your statement. The employee statement is what is often referred to. The other document is a plan sponsor statement, which is a document completed by the employer. The third document is something called an attending physician statement. That statement is completed by your physician. And if your doctor is not supportive of your claim, I don't see why the doctor would have submitted that physician statement in the first instance. So when you submit a claim, you should have the doctor's support as to why it is that you cannot work and why your claim should be approved. And if it is denied, then we assist by advising doctors often what they should do, where they should focus on. We don't tell them what their opinion should be, but we do tell them this is how a disability claim is assessed. It's different from writing a letter for an employer, simply saying my patient is unable to work. The doctors have to focus on what the restrictions are, what the limitations are, and why the person is unable to work. Remember, like I said earlier, many people with depression work, but why is it that you cannot work? There are people who work with fibromyalgia, but why is it that you cannot work with fibromyalgia? The focus is, what are your restrictions and limitations? A disability claim is much more focused on functional impairment versus the diagnosis itself. Diagnosis is important, but what is the functional impairment? Why does your condition impact your ability to perform the essential duties of your own occupation? That is where the focus lies. And that is what doctors should focus on when they submit cases or attending physician statements or write letters in support of their patients. We're running out of time, but there's one more question. You're very welcome. Need a break. Question on YouTube from Jennifer. How can pre-existing conditions affect current disability claims? How are consequential injuries dealt with by disability insurance companies? I can spend a whole segment just on this question, but let's just focus on the first one. How can pre-existing conditions affect current disability claims? A pre-existing condition in layman's terms is not the same thing as a pre-existing condition in a contract, in a policy. I'll use an example. In a policy, a pre-existing condition is a defined term. It may mean, I'll just use an example because they're all really different in the policies. Some policies may say, if you have had coverage under the policy for less than 1 year, then the insurance company can deny your claim if it is due to a pre-existing condition. Pre-existing condition will be defined. For example, we may read as follows. If you have a disability or if you have a disability now and it is due to, associated with, directly or indirectly to a pre-existing condition, then your claim is excluded. Pre-existing will mean a condition for which you receive treatment during a defined period of time. Some policies may say if you had treatment for the condition 3 months before your coverage started, and the medical care in that treatment would be receiving treatment from a doctor, having a consult with a doctor, having prescription medication prescribed to you during those 3 months. If that happened, then there's a pre-existing condition. But you have to look at what the wording would be in your own policy, because they do not all read the same. But it does not mean that just because you had something happen to you before, or if you had depression 5 years ago and never had it again, and now you have it, that is pre-existing. It really depends on the wording of the policy and the medical records. I have seen cases, and I actually have cases in my case now. I always have pre-existing condition cases where there is an argument at our end as to why it is not pre-existing, because the policy is so specific. And if the pre-existing condition language, if the facts don't fit within that pre-existing condition language, the insurance company cannot rely on it, even though in layman's terms, the condition is pre-existing. But that's irrelevant, because we have to look at the wording of the policy. So if your claim is denied because of a pre-existing condition, please do reach out to us, because then really we need to look at what is the policy wording and what are the facts. So thank you for joining today. Thanks for all the questions. Go to the screen, as I said, go and to disabilityrights.ca if you've got more questions. Our next session will be an employment law Q&A session, which is tomorrow at 1 p.m. Eastern Standard Time with Samfiru, tomorrow being December the 18th. Thank you, everyone, and have a great day.